is Jamie Stevens. This is Julia Geyer, and we are co-chairs of Young Leaders on the Council for Life board, along with Marty Washington, who's in the back. She's the Young Leaders for Life liaison on the Council for Life board. And first off, before we go any further, we really just wanted to give a huge thank you to Amy and Malone Mitchell, who opened up their beautiful house to us tonight. And Amy, who's actually provided the quesadillas and the cookies and did the flower arrangements. I mean, she went above and beyond.
She made it.
Yes, yes. And so as we kick off our event, I really just wanted to open us up in prayer. So if y'all will bow your heads with me. Father, we just want to thank you for this evening, that we can come together and learn together and discuss this topic that is so integral to who you are and who we are. Lord, you are the author of life, you are the giver of life, and so we just want to stop and praise you tonight, and thank you for all these wonderful friends who have come together desiring to learn more, desiring to equip themselves so that we may speak more articulately about this topic and in a way that glorifies you, Lord. So I pray that you would bless this evening. Thank you for Ruan and Marisa, who have given so much of their time. Thank you for all the staff members at Council for Life who give of their daily lives toward this important issue, Lord. So I pray that you just bless our time today, be glorified through the conversations that we have, Lord. And we just pray that your name would be lifted up, Lord. We ask all these things in your Son's name, Jesus Christ. Amen. Amen. And so before we kick off, we wanted to kind of give a bit of an overview of the organization of Council for Life, just the history and the work of Council for Life. And we thought, who better to do that than the executive director of Council for Life, who is Leanne Morris. So here's Leanne.
So it is my honor and privilege to tell you about Council for Life. This organization started 21 years ago by a wonderful woman, Ann Caruth, and she's here, and she doesn't like it when we brought attention to her, but we do love to draw attention to her because we're so grateful for her perseverance and her steadfast faith in the Lord and in the life that he creates in the womb. Ann Caruth is here in the green dress. I won't bring any more attention to her. I know it upsets her, but for 21 years, Council for Life has done two things: educated the community, and we have fundraised. And the reason we fundraise is so that we can just send that money out into the community to life-affirming agencies that do the hard work of meeting vulnerable women where they are when they come in frightened and scared because of a pregnancy. We also do these educational events like this one tonight, and for 21 years, we've had more than 30,000 people in Dallas participate in our educational events, and we've raised more than $10 million to send out to these agencies. And so we've had an impact that counts. The type of agencies that we support, we have them on our poster boards out in the breezeway where the food is, but they are generally pregnancy resource centers, adoption and foster care facilities, maternity homes and pregnancy resource centers that also provide abortion pill reversal, which is kind of a new thing these days. But from the chemical abortion pill, there is a time period when a woman can have regret and turn that around with some medicine. And then we also support agencies that offer post-abortion help and healing, compassionate care for women and men who have experienced abortion. These agencies, they provide support, counseling, understanding. They provide the vital necessities for a little young family to be able to survive and get off the ground and flourish once that woman has chosen life for her baby. And then we just wanted to tell you a little bit about us. These beneficiaries, we will fund 28 beneficiaries with more than $1 million this year, and we're very excited about that because that is a milestone for Council for Life. And then, like I say, the posters are in the breezeway, and you can learn more about them or just ask any of our staff. And that will bring us to 21 years ago, Anne and her 10 friends got together and they wanted to start the conversation about protecting preborn life. They wanted to talk about abortion, but that wasn't talked about in polite social circles. And so they wanted to find a way where they could gather people so that they could talk in a grace-filled, loving way about an unplanned pregnancy and all of the complex issues that surround it. And so they crafted core values and a mission statement. And our mission statement is that we exist to empower women, men, and youth to make life-affirming choices. And we are motivated by Christ-like love and responsive compassion. And we're committed, as I said, to raising public awareness of these issues with the educational programs and financial support. We stand on the Word of God and prayer. The last 2 years, our verses, I think it's important to say what they are. Jeremiah 1:5 is our verse for this year. Before I formed you in the womb, I knew you. Before you were born, I set you apart. The Lord did his work for life a long time ago. And so we respect it. We honor the Lord and the dignity of the life he creates. Last year, our verses were from Romans 12:2, do not conform to the pattern of this world, which supports abortion and the killing of preborn life, but be transformed by the renewing of your mind. And then Proverbs 31:8, speak up for those who cannot speak for themselves, those precious tiny babies in the womb. Council for Life is made up of a regular working volunteer board. We have 33 members. We also have an advisory board that gives us wisdom and guidance, made up of pastors and priests, business leaders, philanthropic leaders, and of course, doctors. We have over 1,300 advocates for life, and that's whoever wants to stand with us financially and just with their voice to advocate for the preborn. And we have, as we've talked about, 3 full-time staff and 2 part-time staff, and I'd love for the staff to kind of stand up or come forward or and be recognized. Suzanne Everbach, who's taking pictures. She is our Director of Communication and Philanthropy. And we have Priscilla. I don't know if she's going to pop around, but she may be busy right now. Come here, Priscilla. Overton, and she is the dynamic administrative assistant in our office. And then we have Natalie Siegel, Director of Finance, and she takes care of all the important stuff. Our board member, Marty Washington, is here. Katie Cruz is here. Rosalind Brown is here. And of course, is Amy anywhere nearby? Amy, our wonderful hostess, has been on the Council for Life board for a long, long time, and we're so grateful. In your chair, we have some goodies for you. We have our mission statement. May I borrow your packet? Thank you. We have our mission statement, which on the back of the mission statement has our beneficiaries in case you want to look at those names. The reason I keep coming back to this idea of who our beneficiaries are is because someday you're going to find yourself in a conversation and you're going to need to be able to direct someone, a girlfriend, a guy, a co-worker, a sister, to a pregnancy resource center, to a maternity home. Perhaps it's somebody at the grocery store. Perhaps it's somebody at FedEx. It's happened. We hear these stories all the time, and I want you to have these names of the beneficiaries. And of course, I want you to have our core values and our mission statement. And so also in your packet, we have a lot of other things, other information. I'm going to get to all of that really quickly. The resources. We have a list of books that will help you if you want to learn more about the issue. Movies that are very, very powerful. And we're going to play a few excerpts from a movie this evening. I like songs. I like singing about life, so I have a few song recommendations, and social media. And we want you to know what Texas does for women. We have all of our pregnancy resource centers here in North Texas, and we talk about them all the time, and we want you to know about them. But that's not the limit of it. There's more. Throughout the state of Texas, we have over 300 pregnancy resource centers and dozens of maternity homes. The state of Texas provides $100 million in funding for these resource centers. $50 million in 2022 and $50 million in 2023. We stand by what we say when we talk about life in Texas. And then on the back of this infographic is what we call this. On the back are some abortion statistics. They're devastating. They're hard to read, but we want you to be prepared for when you have these conversations. And then I just want you to know that there is compassionate care available for women in unplanned pregnancies. So part of our education is that we have 2 more events coming up. We're going to talk about the final Dobbs decision. Today we're talking about it in theory, but when it actually is issued by the Supreme Court, we will have an event September 7th at the Dallas Country Club, and you all are invited to hear our speaker, Ben Domenech, analyze the decision and what life is going to be like in a post-Roe world, we pray. And then our final kind of culminating event is our Celebrating Life Luncheon, November 14th at the Anatole Hotel. Jim 𝐃𝐨𝐿 is our speaker. He's ardently pro-life, and he has had to stand courageously in Hollywood and talk about life, talk about his faith, be ostracized, suffer mockery and persecution for what he believes. And we are grateful that he is our speaker. And then I want you to know that in your little packet, you have a save the date for the luncheon, and that'll help you, remind you. And then we also have our Advocate for Life card so that we can get to know you. We want you to be an advocate for life. We want you to help us support these beneficiaries, and you can do that for as little as $1. But we would like you to fill out the card and give us information about you, your address and your email, and that sort of thing. And so the last thing I wanted to do and then is just turn this over to Julia, and she is going to introduce our speakers.
Hi, I'm Julia. I just want to thank Ruan and Marisa for being here. They both just graduated last weekend, so they prepared for this. Very grateful for that they're going to kind of help us have the tools to have these conversations and be equipped. So I'm going to just read through bios. So Marisa is a proud Dallas native. She graduated from the University of Notre Dame with a degree in electrical engineering. She then went to work for AT&T in various engineering jobs before attending SMU Law. At SMU, she was president of the SMU Dedman Law Students for Life organization. This fall, she will join the patent litigation group at Winston & Strawn in Dallas, and in August 2023, she will start a federal judicial clerkship with Judge Amos Mazant, is that right? Of the U.S. District Court for the Eastern District of Texas. So thank you, Marisa. You guys aren't busy at all. And then Ruan Meintjes, South African last name. Ruan Meintjes is South African by blood, Cajun by birth, and a Texan by heart. After being raised on a sheep farm about an hour north of Dallas, Ruan graduated from Patrick Henry College in Northern Virginia. He returned to North Texas, where he managed a specialty medical company in Frisco while earning his master's in conflict management and dispute resolution. After the sale of the company to a private equity platform, Ruan pursued and recently graduated 2 days ago with a JD MBA from SMU. Ruan currently serves on the board of Life Talk Pregnancy Resource Center in Frisco, and he will join Kirkland and Ellis as an associate in the fall. He's joined this evening by his lovely wife, Ellen, and they are expecting their first child in August. So, congratulations.
Thank you all so much for being here. It's so exciting to see a room that is this full with young people. It is just, it's exciting. My job today is to give you a Reader's Digest version of Roe versus Wade, how we got there, and then how we ultimately got to where we are today with the leaked opinion in Dobbs. So I want to start by telling you the story of Norma McCorvey, who we met in the video. She's a very enigmatic figure. It's difficult to know what about her life is true, what's not, what's been politicized. But I want to share with you just some of the details that we know for sure. The first is that she was from Louisiana. She had a very difficult childhood, stories of abuse, poverty. By the age of 21, she was on her third pregnancy. Her first two daughters she had given up for adoption, and when she was pregnant for the third time, she moved to Dallas County, where it was illegal to receive an abortion. And by the time she was pregnant for the third time, she really wanted to have that abortion. She had, according to the stories that are out there, she had sought for options about what to do with her third pregnancy, and she came across a couple of abortion lawyers that were looking for a perfect case to challenge the Texas law that made providing an abortion a criminal offense. And she was the perfect fit for what they needed to do. So they packaged her story, litigated that through the courts, and she became the Jane Roe in Roe versus Wade. So what I want to do today is take you through 3 steps. I want to give you an idea of what the historical arc is of Roe versus Wade. Then I want to tell you what the current state is of the law in the United States, what is abortion law today, right now. And then finally, I want to just educate you a little bit about what we see in the leaked opinion in Dobbs and talk a little bit about where that might take us. And then it'll be a perfect segue over to Marisa, who will talk about a little bit more locally what's going on and what the impact of these decisions might be. So let's talk about this historic arc. A little bit, indulge me in just a little bit of some legal technicalities. When we talk about our rights, we look to the Constitution and we look to what's called the Bill of Rights. Those will be the first 8 amendments to the Constitution. So when we think about what our rights are as an American citizen, we think about this Constitution and the Bill of Rights. Well, in the 1930s, up until this point, we knew exactly what our rights were. They were written down. But after the Great Depression, the government wanted to start doing some more things on an economic basis, and they needed a way to get there. So the court invented what's called substantive due process. And that literally just means you look at the Constitution, you look at the Bill of Rights, those first 8 amendments, and you try to find some fundamental right. You try to discover it. It's not necessarily written in the text, but it's there. And you can argue that it's there based on some tradition in our nation. But what this effectively did is it allowed the judicial branch to create fundamental rights in a way that up to this point, only the legislature could do by passing a law or amending the Constitution through a legislative and elective process. So Roe versus Wade, the story of Roe versus Wade started in the 1930s. In the 1960s, we had the sexual revolution, and the court used substantive due process, that process of discovering a right in the Constitution, to look at laws that regulated contraception. So several states had restrictive laws on the type of contraception that people could use. And the court discovered what they called a fundamental right to privacy. That is that the government has no business intruding into the bedroom and telling you how to use contraception. So we established this right of privacy. This was in the late 1960s. Then in the early 1970s, with Norma McCorvey's story, the right to have an abortion was a natural outgrowth of that right to privacy. So we're all tracking. That's how we got there. We started in the 1930s with the economic issues, and then we got to Roe versus Wade, which said you have a right to get an abortion up until the point of viability of the child. That is the time when the baby can be born and survive. So with that being the case, states could regulate anything after that, but they could not put a restriction prior to viability. So this goes on for about 20 years, and then we come to Planned Parenthood versus 𝐃𝐶e in the early 1990s. So what had happened is different states, some with more conservative political leanings, were trying to restrict the right to abortion or make it a little bit more difficult to have an abortion within the confines of Roe versus Wade. So Pennsylvania passed a statute that said, look, if you're going to have an abortion, there's a spousal notification provision. Before you have an abortion, you need to wait 24 hours before you can actually have the procedure. And what Planned Parenthood said is they said this, and the court agreed, that this poses an undue burden on a woman's right to have abortion because you've got laws that are taking place in the first part before that child is viable that it is making it difficult to have an abortion. So the rule that came out of 𝐃𝐶e, and I'll summarize this again for you in another slide, but the rule that came out of there was that no state, no government entity may place an undue burden on a woman seeking to have an abortion prior to the point of viability. There was no discussion about at what point is viability. We still don't know. Most medical experts agree that it's going to be around 24 to 26 weeks. And I brought my lovely wife along. She's 26 weeks pregnant now, and she'll tell you pregnancy is a very real thing at that point. So after 𝐃𝐶e, when the rule was we have no undue burden on a woman's right to an abortion prior to viability, we have everything that's led up to today, which is mostly states trying to pass laws that are going to make someone think before they have an abortion or have an abortion at an approved surgery center, things like that. You've seen that on the news. So just to summarize, we have Roe versus Wade in 1973. That gave you a fundamental right to an abortion that came out of the right to privacy. Then we had 𝐃𝐨𝐛𝐬, which basically said, we're going to set aside some of the reasoning in Roe. They didn't compliment it. They said Roe has proven a workable solution, so we're not going to overturn it. It's not great, but it's not unworkable. And we're going to measure all state laws based on the question of, does this pose an undue burden on the right of a woman to have an abortion prior to the point of viability? We still don't know exactly when viability is. So this brings us to today. Mississippi took a Hail Mary approach, and they said, we are going to ban all abortions after 15 weeks. So the generally accepted standard for viability is between 24 to 26 weeks, depending on which hospital you're in. And Mississippi said, no abortions after that point. So then we got the leaked opinion in Dobbs. And Dobbs, according to the leaked opinion, which was in February, and it could still change substantially, but it basically did away with everything in Roe and 𝐃𝐨𝐛𝐬. And it really does so in two steps. The first is that it says the reasoning in Roe was profoundly wrong. And reasonable minds can differ, but I'm a really big stickler for intellectual honesty. And I think anyone, even some of the most liberal proponents of Roe versus Wade, will admit that Roe versus Wade is an intellectually bankrupt decision. And what I mean by that is when the Supreme Court goes and they write a brief, they're supposed to root it in constitutional law and precedent. But when you read Roe versus Wade, it's a relatively short opinion. It mostly talks about history, and it misrepresents history. It's been widely criticized for that. It doesn't talk about constitutional law. It quotes some of the American Medical Association's positions on the subject, sprinkles in some of the Hippocratic Oath. This is not typically things that you find in a Supreme Court decision deciding an important point of law. It was not rooted in our history. And so what 𝐃𝐨𝐛𝐬 did is when it came along and it had the chance to overrule Roe versus Wade, they said, well, it's proven workable. It's not a problem. We can work with it. It might not be perfect. But because we have already made this decision, we are worried that people have relied on it, and that if we change our tune 20 years after Roe versus Wade, people will lose respect for the institution of the court and its standing. That was very clearly in their reasoning, almost verbatim. So based on that, the current draft of Dobbs overturns Roe versus Wade and 𝐃𝐨𝐛𝐬. So it's basically saying Roe was wrong, and 𝐃𝐶 reaffirmed Roe without actually adding any substantive reasoning or justifying it. So the result, if you go to the bottom end of the opinion, this is what happens. It says abortion is not a fundamental right under substantive due process. It doesn't exist in the Constitution. We shouldn't have, quote unquote, discovered the right in the 1970s. And so what this does is it kicks it back to the states. Before Roe versus Wade was law, individual states would regulate abortion. Some would allow it, some would not allow it, and it was working its way through the political process when Roe versus Wade jumped in and pulled it out of the political process and became a decision from the court. So now, under the current decision, it'll go back to the states, and that's what Marisa's going to talk about. So I want to end by introducing you to Shelley Thornton. This is the daughter of Norma McCorvey. This was her third daughter. This is who she was pregnant with when she filed the lawsuit in Roe versus Wade. She was born before Roe versus Wade was handed down from the Supreme Court. And I don't mean to co-opt their story for one political narrative or the other. If you study the family, they're very resistant to that. But I do think it's really worth pondering what would have happened if Shelley Thornton or the court's timing was different, and if her life could have had a different outcome. So with that, I want to hand it over to Marisa, and we'll look forward to some questions after this presentation.
So like was said before, my name is Marisa, recent grad. Wanted to thank Counsel for Life for having us to speak. The Mitchells, I don't know where they are, but thank you so much. Thank you so much for having us in your beautiful home. Can everyone hear me okay? Yeah. My voice is a little tired after graduation weekend, so I apologize. So I'm going to talk through, I'm going to talk through the state of our state laws right now in Texas. So the main two that I'm going to hit are the Heartbeat Act and the Human Life Protection Act of 2021. So as Ruan mentioned, states right now under the framework in Planned Parenthood versus Casey that established this line of viability. Because before in Roe versus Wade, the framework that was established was this trimester framework that, like Ruan mentioned, kind of came out of nowhere. But then Casey came in, changed the framework, and said, well, we're not overturning Roe. That's still good law, but we're going to change the complete framework upon which Roe was based. So take of that what you will. But so right now we have the Texas Heartbeat Act that does regulate before viability, and I'm going to explain how it does that. So the Texas Heartbeat Act was enacted in the last legislative session in 2021. So it was enacted on May 19th, and it was effective on September 1st. It's also commonly known as SB 8 because that was its number in the legislature in 2021. It's a little bit unique in that it's a civil right of action. So there's no criminal liability associated with it, which is kind of unique because other abortion laws will criminalize abortion. So they will criminalize typically the abortion provider, typically the woman who is seeking an abortion or who the abortion is performed on, not very commonly made a criminal for that, and that is not what the Heartbeat Act does. Another reason that it's very unique is that it's enforced by private individuals. So what does that mean for us? Typically, when there are laws that are, especially with abortion laws, that are passed, the reason why they are typically struck down so quickly is because if you want to try and strike down a law prior to its enforcement against an abortion provider, you have to be able to sue a state official because that state official would be the one enforcing the law. However, the Heartbeat Act does not allow anyone who's a state actor to bring a lawsuit. It only allows private individuals to bring lawsuits for anyone who aids or abets someone pursuing an abortion. And so that has made it unique in that it has survived judicial challenge in the federal courts. So I pointed out a few of the attempts at subsequent litigation to try and enjoin this law, United States versus Texas and Whole Women's Health versus Jackson. And in both of these attempts, the Supreme Court has not said yet that this law is constitutional or not. What it has really done is it has said who can sue under this law and who can be sued under this law. So in United States versus Texas, in Whole Women's Health versus Jackson, Whole Women's Health was trying to bring the lawsuit against Ken Paxton, against some state judges clerks, and against state medical licensing boards. So far, the only thing that the Supreme Court has said is no one can bring a lawsuit against a state judge, against Ken Paxton, against a state law clerk, but they can bring them against state licensing medical licensors. So that's the state of the law currently. It's still kind of going through the courts, but I would imagine it has not been determined to be constitutional or not because they are probably going to wait to decide Dobbs first. Because if Dobbs is constitutional, and then looks like there won't be a problem with the Heartbeat Act. So. Oh, okay. The other one is the Human Life Protection Act of 2021. This was also passed in the 2021 legislative session, and it's also commonly referred to as the Texas Trigger Law because it will be triggered if there is any overturning of Roe versus Wade or a constitutional amendment or anything that would make abortion go back to the states. So it was enacted in June. It was effective September 1st, but Section 2 of the bill, which is the bill that actually would reverse or put into place the criminalization of performing abortion, that would only go into effect 30 days either after Roe versus Wade is overturned or if there's a constitutional amendment, etc. And what it does primarily is it criminalizes the performance of abortion with some carved out exceptions in the case of the life of the mother. And that's in specific circumstances that are laid out in the bill. And like I mentioned before, also important to note that it does not criminalize the person upon whom the abortion is performed. It criminalizes the person who performed, induced, or attempted to perform the abortion. Okay, so how does the U.S. look if Roe versus Wade is overturned? I think that it's a common misconception that abortion would be automatically illegal if Roe versus Wade is overturned, and that's not correct. What will happen is the decision will go back to the states to determine whether or not they want to have abortion be legal or illegal in their states, and if they want it to be legal, if they want any regulation of any type. So right now, this is a map of the states that have trigger laws similar to Texas. So again, trigger laws would be those laws that somehow make abortion illegal if Roe versus Wade is overturned. So Idaho, Utah, Wyoming, North Dakota, South Dakota, Missouri, Kentucky, Tennessee, the home of Texas's favorite person, Davy Crockett, Mississippi, Louisiana, Arkansas, and Oklahoma. So we have a few of those states that already have trigger laws in place. We also have some states that still have their pre-Roe versus Wade laws on the books, so laws that criminalize abortion, but those laws currently cannot be enforced because Roe versus Wade is the current state of the law. And then there are some other states that are likely to implement bans, but just it's not quite clear yet. One thing I will note, just for all of you to know, this map I got from public news, but it was made using resources from the Guttmacher Institute. And for those of you who don't know what the Guttmacher Institute is, it is the research arm of Planned Parenthood. So I would say if you're researching abortion, it's generally actually a decent source because they have an interest in providing some decently good information, but always tread lightly because they will frame things in a way that sometimes is not true. So I like to share that in the interest of intellectual honesty, like Ruan mentioned. So this is another heat map of kind of where we are now as far as where abortion is being regulated in the United States and to what extent. So right now, we're over here on the left, so before Roe versus Wade has been overturned, so you can kind of see a heat map of the different levels at which it's regulated. The darkest color is no restrictions up until the point of birth, and then the lightest color, which is Texas, which is at 6 weeks, and that's because of the heartbeat bill that does not allow abortion after you can detect a fetal heartbeat, which is around 6 weeks. So after Roe, this is what the map would likely look like. It's a little bit off. These darkest colors are the ones that would not restrict abortion. There's actually 4 states that would not restrict abortion. I believe Colorado now is one, and then there's one more, and then DC would also have no restrictions up to the point of birth. So I wanted to share this map just to kind of give everybody an idea of what the country would potentially look like. And so you can see a lot of states would ban abortion to some level. Something that's interesting to note is Illinois, which is right among a bunch of these red banning abortion states. In some ways, it's being affected because its lines to wait for abortion appointments are so long, it's effectively become really hard to get an abortion in Illinois. So that's kind of a win for us, even though unintentionally. But also sad that there are that long of wait times because so many people want them. So this is just a little bit of an overview of the type of dynamic legal changes that we're seeing in Texas and around the country. So we've seen lots of advocates for life stepping up for the preborn. So you see the Heartbeat Act, the Dismemberment Act, which was an act making a D&E or a dismemberment abortion illegal. We have sanctuary cities all around the state of Texas, and those are cities who have essentially made them sanctuary cities for the preborn. So no abortion clinics or abortion facilities can be built in those cities. We also have the Dobbs case in Mississippi, and we also have the Oklahoma Heartbeat Act, which is very similar to that of Texas. Lastly, I wanted to leave everyone with this message that overturning Roe versus Wade would simply be the beginning for us who are all advocates for life. Because as the power returns to the states, advocates for life have to remember that abortion is not just going to go away. And just as, there are cities like Lubbock who become sanctuary cities, there will also be cities who do things like ban crisis pregnancy centers. Because there's a lot of messaging around what a pregnancy resource center does, and there's a lot of incorrect messaging about what pregnancy resource centers provide. So I wanted to make sure to leave everyone with that message, and also leave everyone with this. As we pray, if Roe versus Wade is overturned, there are going to be a lot of people who did not sit through this presentation and are going to be really scared and really confused. They're going to be really confused because this has been perceived to be a constitutional right since 1973. And so everyone in this room, pretty much, and especially people in younger age demographics, have been convinced that this is a constitutional right. They don't know what you now know, that Roe versus Wade is very, very weak on its legal reasoning. So it is up to us to educate the public on why Roe versus Wade was wrong and why abortion is not a constitutional right. But second, people are going to be scared because something that they potentially felt that they needed is now no longer going to be available to them. But it's going to be up to us who are advocates for life to tell those women who are scared, to tell those men who are scared, you don't need abortion, what you need is support, and we're here to provide it for you.
Thank you.